Today we are looking at a defense to the non-payment of rent that could apply to as many as 100,000 apartments, but almost no one knows about this defense or how to properly utilize this defense. But after today's episode, you will understand much better. New York City tenants have more rights than tenants anywhere else in America. But New York City tenants are also shockingly uneducated about what those rights are. A right you don't know you have is the same as no right at all, and there are so many bits of incomplete information out there. This podcast will change all that. In each episode, we look at current legal cases and statutes and the real-life apartment stories they give rise to here in the greatest city on earth. And every episode ends with a tenant takeaway, so you have actionable information to help you make better choices. The law belongs to you, New York City, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I'm Michelle Itkowitz, and this is Learn to Live Better, a housing law podcast. Okay, so as always, let's start by setting the stage with some context so you can know what you need to know to make today's case meaningful to you. In New York, we have the multiple dwelling law, What's a multiple dwelling? A multiple dwelling is any building with 3 or more residential units, and the multiple dwelling law applies to it. Multiple dwelling law 301 requires multiple dwellings built after a certain date to have valid certificates of occupancy, a certificate of occupancy. Not every building will have a certificate of occupancy. Most will. But some won't because those buildings are grandfathered or they're exceptions within the statute. But most buildings will have a certificate of occupancy. And what's the significance of that? A certificate of occupancy is a document that tells the world how the building may legally be occupied. I have a sample certificate of occupancy on the slide that we're looking at now. And by the way, if you're not watching this podcast, that is just fine. I will always express things verbally in a way that you can understand what's going on. Over on the left, I have a sample certificate of occupancy that's not just any certificate of occupancy. It's actually the one that goes along with today's case. I looked online and I found it. This one tells us, what does it tell us? That in the cellar, it is an ordinary use for a cellar. Then the first floor has or may have 8 families and a doctor's office. The second floor may have 9 families. The third floor may have 9 families. The fourth floor may have 9 families. And the fifth floor may have 9 families. The sixth floor also may have 9 families for a total of 53 families. That's a certificate of occupancy. Now, where do you find these documents? You find them on the New York City Department of Buildings website. That, unfortunately, recently has gotten a little bit more complicated, and I think a couple of words on that is worth it. I have another image on the slide, and again, you don't need to be looking at it, which is an example of part of the Department of Buildings website called DOB Now. And some information about a building will be located on the DOB Now portion of the website, the most recent information. However, sometimes there might be more information on this under the building information section of the Department of Buildings website. I just changed the slide and I have a screenshot of what the building information system portion of the Department of Buildings website looks like. Whatever you're looking up about a building, maybe you're looking up permits, maybe you're looking up complaints, maybe you're looking up violations, maybe you're looking up the certificate of occupancy, whatever you're looking up, unfortunately, if you really want to do a thorough check of what's going on a building, these days, you have to look in both places. Okay, so what's the significance of all this? There's a certificate of occupancy. This one says that they can put 53 families in the building by putting the 9 apartments on floors 2nd through 6th and 8 apartments on the first floor. What is the significance of this? What happens if the landlord doesn't comply with multiple dwelling law 301 and puts more families in a building? Well, that brings us to Multiple Dwelling Law 302. Now, we are going to go through this briefly. I'm not going to read a lot. I'm going to sort of read, sort of paraphrase. The law is words, people. The law is words, and your landlord is reading those words, so we're going to read a few words as well. Multiple Dwelling Law 302 tells us that if any dwelling or structure be occupied in whole or in part for human habitation in violation of Multiple Dwelling Law 301, then two things can possibly happen, two consequences. No rent shall be recovered by the owner of such premises for said period. One more time. No rent shall be recovered by the owner of such premises for said period, and no action or special proceeding shall be maintained therefore or for possession of said premises for non-payment of such rent. Put in plain language, if the landlord is causing the building to be occupied in a way that's contrary to the certificate of occupancy, the consequence is that the landlord can't recover rent. And even more than that, the landlord can't sue to recover the rent. Now, that is obviously pretty powerful. However, as soon as I tell anybody about the Multiple Dwelling Law 302 defense, I always want to add the following. Here's the catch. Where rent has already been paid, however, it can't be recovered by a tenant from the landlord pursuant to Multiple Dwelling Law 302. And to support that, I have an appellate term First Department case here on the screen called Goho Equities versus Weiss. Appellate term First Department, 1991. So I always think it's important to add that. Why? Because whenever I see a tenant not represented by a lawyer, often when they are employing the Multiple Dwelling Law 302 defense, they will also be counterclaiming to sue the landlord to get back rent that has already been paid. Because they read the statute and they think, oh, well, this means no rent was ever owed, which that's not what it says. I can sue to get the money back. And I just think it's very important that people understand what's going on to manage their expectations so they can make the best decisions about what they want to do next in a lawsuit. You might be inclined to fight harder if that's what you think is the pot of gold at the end of the rainbow, but that pot of gold is not there. In other words, here's a good way to put it. Multiple Dwelling Law 302 gives a tenant a shield from being sued for the rent, but it's not a sword where the tenant can sue to get rent back. And it's just important to keep that in mind. Okay, and that sets the stage. And now we are on to today's case, which is 8224 Bay Parkway LLC versus Odom. This is a case that comes to us from the Civil Court of the City of New York Housing Part in Kings County in Brooklyn, 2025. I think specifically this came down in August of 2025. It's a housing court case. Now, in this case, it's very interesting. The tenant first came in and the tenant did not have a lawyer. And then the tenant got a legal aid lawyer, a lawyer for free. And the legal aid lawyer put in an answer on behalf of the tenant. And that answer said that the certificate of occupancy for this subject building allowed the landlord to rent to 53 families. However, there was a 54th. The landlord had built an illegal apartment in the basement. The tenant goes on to allege that the Department of Buildings issued 2 violations to the subject building for occupancy contrary to the certificate of occupancy, and that those violations were still existent when this case was being heard by the court in 2025. And not only were there 2 violations issued by the Department of Buildings, but it went even farther. In 2022, Oath, I'll tell you what that is in a minute, issued a decision crediting the Department of Buildings evidence and the Department of Buildings inspector's testimony as to this observation, which indicate that an additional living space was created in the cellar. Okay, what's Oath? What is this extra piece of information? There is in New York an Office of Administrative Trials and Appeals, OATH. We have a big city. The city has a lot of administrative agencies, such as the Department of Buildings. The Department of Buildings filed 2 violations against this subject building. Now, what if the owner of the building wanted to contest those violations and say, no, those violations were put there wrongly? Well, now you need some kind of adjudicative process. You need a hearing. And the Department of Buildings doesn't do that internally. It, like many other agencies, sends its hearings to the Office of Administrative Trials and Appeals, and that will hold a little hearing. And that's what happened on these 2 violations on the case we're looking at today. They sent this to the Office of Administrative Trials and Appeals for a little hearing, and the landlord lost in 2022. So there was an administrative decision saying, yes, the building was used contrary to the certificate of occupancy. Because of that, tenant said, look, Your Honor, we don't even need a trial here. The landlord said, wait a minute, the violation that the landlord got implicated the basement. But this tenant didn't live in the basement. They weren't living in any legal apartment. No. They were in a legal apartment. So this multiple dwelling law 302 should not provide a defense for that tenant. Well, the judge in our case today in Odom pointed to a Court of Appeals case from 2012 that already dealt with this very issue. That's how the law works. Judges look at earlier decisions of usually higher courts. And in this case, there was the Chazon LLC versus McGinniset case from 2012 at the New York Court of Appeals. In New York, the highest court is the Court of Appeals. That's our highest court. Chazon says that it doesn't matter where the illegal apartment is in the building that is causing the building to be occupied contrary to the certificate of occupancy. It doesn't matter. This issue was already settled. The Court of Appeals, the highest court in New York, already decided in 2012 in Chazon that basically multiple dwelling law 302 is a building-wide defense. Any tenant in the building can raise the defense and have that be a shield from the landlord suing for the rent. Based on this strong, unequivocal language from our state's highest court, the judge in today's case dismissed the non-payment case against the tenant. Now, that sounds pretty straightforward, but it really honestly raises so many important and nuanced takeaways. You can't leave me before the takeaways. But first, let's get the housekeeping out of the way. This is not legal advice. I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is terrible because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. Please like, subscribe, give us the very highest rating, provide a great review, and spread the word in any way you see fit. If you're listening on the Tenant Law podcast feed, please consider going over and also subscribing to the show a second time anywhere it's hosted by the Broadway Podcast Network. That will really help us get this information to more New York City tenants who need it. It's time for the tenant takeaway. Okay, it's tenant takeaway time. Tenant takeaways number 1 and 2. These multiple dwelling law 302 defenses are obviously very powerful. If a building is occupied contrary to how the certificate of occupancy on file with the Department of Buildings says that building can be occupied, then that creates, in essence, a building-wide defense to a non-payment case. But again, as soon as I say that, I always want to follow it up by reminding you that a multiple dwelling law 302 situation is not a sword. It's not a basis to recover rent that's been paid during the existence of the condition. Rather, it's a shield. It prevents the landlord from being able to sue for the rent and to recover the rent. Takeaway number 3, the multiple dwelling law 302 defense is powerful, but it's also hard to achieve. I really want to emphasize that. Today's case was an interesting case because it was the perfect storm. It was a perfect storm of badness for the landlord and the perfect storm of goodness for the tenant. Because what you had there was violations that demonstrated prima facie evidence that there was a multiple dwelling law 302 defense. The violation on file with the Department of Buildings, there were a couple of them, established that it was supposed to be a 53-unit building, but there were 54 units in the building. And it's interesting because I wonder if the tenant in today's case even knew that this condition existed. There was an illegal basement apartment. Maybe they entered that apartment around the corner. I don't know. But it's entirely possible that the tenant in today's case didn't even know the condition existed. But the violation was there. And even more importantly than the violation being there, there were the oath adjudications where the landlord had a chance to fight the violation at the city level and lost. And based on those oath decisions, the court was able to give the tenant summary judgment, which means the tenant won without a trial because there was nothing to talk about at a trial. The issue of whether or not there was a multiple dwelling law 302 condition that would suspend the landlord's ability to sue for the rent, that had already been litigated and proven at oath. So it was kind of the perfect storm. Most of these cases are not going to be the perfect storm. That doesn't mean that you can't utilize the multiple dwelling law 302 defense. That's what we're working on next. Stick with me. Tenant takeaway number 4. I saw estimates online that there are possibly 100,000 illegal apartment units, illegal residential units in New York City. Some estimates said 50,000. Now, this is the first thing. A lot of those, of course, are going to be illegally converted basements, but it's not just basements. This is very important to keep in mind. It could also be illegally converted attics. And also, and this is really ubiquitous, regular apartments rented out as illegal SROs, single room occupancy units. So it'll be one apartment, but it'll really count as 4 dwelling units if there's 4 rooms in there, all with locks on the doors that are being rented to 4 different people. So that will also increase the number of units and possibly, therefore, give rise to a multiple dwelling law 302 defense. So now, what do we do with this? Tenant takeaway number 5. Step 1 to utilize the multiple dwelling law 302 defense is to just pull the building certificate of occupancy from the Department of Buildings. As we spoke about earlier in today's episode, there's a couple of places on the DOB website to check for that. So no certificate of occupancy, this defense doesn't work. Most buildings have certificates of occupancy. Find it and look at it. Step 2, trust your eyes. Do you see an illegal use? Let's go with the example. There's a 3-floor building with a certificate of occupancy on file with the Department of Buildings that says 1 apartment on the 1st floor, 1 apartment on the 2nd floor, 1 apartment on the 3rd floor, nothing else. If you live in one of those apartments and yet you see that there are people living in the basement, there is an apartment down there. Okay, so you might be in business here for this defense. Step 3 is you're going to now check on the Department of Buildings website for violations. Violations are great, as we saw in today's case. Violations create prima facie evidence that the condition exists. If there's a violation, it's prima facie evidence that that condition exists. That doesn't mean that the landlord can't refute it, but it means it's going to be much harder for the landlord. Let's keep going. All right, tenant takeaway number 6. If you're not seeing an illegal unit, and if there's no violations, that's probably the end of the road. Okay, but let's say that there is no violation, but you are seeing it. What do you do then? You're seeing the illegal apartment. You know it's there, but there's no violation. All right, for that, the first thing I'm going to say is try to get them violated. That is a possibility. Dial 311, better yet, do 311 online, make a complaint, and the Department of Buildings will send someone out. Now, here's the problem. I also saw an estimate that there are 25,000 complaints about illegal apartments each year. My experience is sometimes the Department of Buildings will come out and they will knock on the door of the allegedly illegal apartment. And if nobody lets them in, then they're not in a position to write the violation ticket. So they might come back again, they might not. So let's say you're not working with a violation. That doesn't mean you can't prove a multiple dwelling law 302 defense. It's just going to be harder. Your main way to prove such a defense will be with testimony. Just say what you see. I see people coming and going from there. I see the same people all the time. I see them going to work in the morning. I see them leaving with a stroller. I see them coming back with a stroller. I see them coming in and out with their bikes. I see them getting Amazon deliveries. I see them getting takeout food. I saw the moving truck come when they moved in. I say hello to these people in passing. I know people live there. I see the lights on in the basement windows at night. There's an air conditioner in one of the basement windows. Whatever you're seeing with your own eyes, that's what you will testify about in court. And you could have other neighbors testify if they're willing. Sometimes that's tricky. But then again, remember, this defense will provide a defense to everybody in the building. So your neighbors might be interested in helping, or other people in your family or friends of yours who have seen the same thing that you've seen that are willing to testify under oath. Also, pictures and videos. I'm not saying get into violate the privacy of your neighbors, but if you see a big bunch of Amazon delivery, a Chewy delivery for their dog, take a picture, take a video, document what you're testifying to with pictures and videos. You could look up rental ads for the building and see if the landlord had listed the basement apartment. Often they don't list the illegal apartments, but crazier things have happened. So rental ads, brokerage sites, and then gas and electric hookups to the basement as a separate unit, if the basement has a separate meter, that kind of thing. Okay, so you can prove a multiple dwelling law 302 defense with testimony. Takeaway number 7, if there are DOB violations, Department of Buildings violations, that's great. But then take that a step further, like we saw in today's case. Then also do a search, as we discussed earlier in the episode, for oath adjudications. That's how you get to as great a result as they got in today's case. Takeaway number 8. If you get this far and you're utilizing the multiple dwelling law 302 defense, to use this advantage strategically. This is a tricky one. If you're not in a forever home, if you're not in a rent stabilized apartment, if you're not in a durable good cause eviction law protected apartment, what is it you really want out of this overall? Maybe a lot of times what people tell me they want is more time to move with free rent and a good reference. Sometimes they want to renew for another year. You can use a dismissal like this to your advantage to say, look, I understand now you have to bring a whole other case. And you can only do that after you clear this condition. And that could take you a minute. But you know what? I wasn't going to stay here anyway. I was leaving anyway. So this is what I want. I want the free rent that I've earned through this defense. I'm going to want another 6 months of free rent. I want a good reference letter. And I don't know, I want $5,000 for my moving truck. And in exchange, I will agree to get out at the end of the 6 months. You don't have to start all over again with a new case, which you can't even start until you clear the multiple dwelling law 302 condition. Again, it's one of the biggest mistakes I see the unrepresented middle class make, which is they stumble onto a procedural defense. And this isn't exactly procedural, it's substantive, but it's not durable. It's not a durable substantive condition. It's not like we found a way to say that, oh, you're rent stabilized, you can stay forever. What we found is something that means you don't owe the rent, but when they clear the condition, then rent will be owed again. So whenever you get a leg up in a case, you should be connecting the fact that now you've got some leverage and try to negotiate to get that you really want. Okay, so there you have it. The law belongs to you, New York City, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I'm Michelle Itkowitz. This is Learn to Live Better, a housing law podcast.